Hello everyone, we are back with another Ask Me Anything session, rather an informative session. We warmly welcome you all viewers. So this is Advocate Aashi Pawar, Deputy Vice President Legal Services at NRI Legal Services. Today's topic is RERA courts and dispute resolution. The reason we have chosen this topic is that we have been receiving a lot of queries from our NRI clients pertaining to the RERA tribunals. They are often very confused whether to approach the consumer forum or the RERA tribunals. So I hope that by the end of this video, you all will get much more clarity regarding the functioning of the RERA tribunals. So before we begin with the main topic, I would like my colleague to introduce herself.
Hello viewers, this is Advocate Shweta, Legal Associate at NRI Legal Services, and in today's video I am going to assist Ms. Aashi in the topic of RERA courts and the related disputes of it. Shall we start?
Yeah, thank you Shweta. Okay, so let's understand what is RERA Act. So the Real Estate Regulation and Development Act 2016 is an act that creates a system of checks and balances of the buyers and the builders. So the objective of this act is to create a code for the real estate market of India. Prior to the commencement of this act, there was not any effective regulatory that dealt with the real estate market of India, which led to many agitations and disputes between the buyers and the builders. So after the implementation of this act, it has created a very positive impact upon the real estate projects, upon the developers, upon the potential and existing buyers, the stakeholders, shareholders. So approval of RERA is an incentive for the buyers because now they are very much confident that in the project in which they are investing is actually governed by the central authority. So their hard-earned money is not losing, right? So let's, I'll discuss now the perks of RERA Act. So this Act, the Real Estate Regulation and Development Act 2016, has created a sense of responsibility, accountability, transparency between the buyers and the builders. Since it is obligatory for all the projects to be registered with the RERA authority prior to its commencement, now the buyers are less bothered of being mistreated. Right, Shweta?
Yes, ma'am, absolutely. In fact, I would like to add that apart from this, we must understand that the RERA Act is so well designed that it safeguards the rights and interests of both the parties, that is the developers as well as the buyers.
Yes. As it is essential for all the states to establish the state-wise regulatory bodies as instructed by the Act, now the real estate developments are now more streamlined, and again the buyers are now very much confident in investing their hard-earned money in their projects. So there is a less chance of harassment also on the part of the buyers. Like Shweta has very rightly said that yes, this act has created a balance and is looking after the interest of both the parties, the builders and the buyers, right? So
yes,
okay.
And in fact I would also like to add a very important limitation that has been put by the RERA authorities over the developers. So after the commencement of RERA Act, the developers are not allowed to advertise their project group without seeking the proper permissions of the authorities. Moreover, the RERA authorities have also put a bar over the booking amount of the project group. So from now on, the builders cannot charge you more than 10% of the property cost as the booking amount. So that's something that must be remembered, right?
Yes, right, Shweta. Okay, so now I'll talk about the RERA tribunals. So if any person is not happy with the acts and conducts of the developer, the aggrieved party can approach the RERA tribunal established in the jurisdiction where the property is located, right? So when the order has come and the person is not very happy with the relief granted by the RERA tribunal, what you can do is you can file an appeal in the appellate RERA authority. After this, again, if you are not very much happy with the order of the appellate authority, you can go to the concerned High Court of that state. Again, you can go up till Supreme Court of India if you are not happy with the order of the High Court. So yes, you have 3 appellate jurisdictions under the RERA authority, right?
There's always a confusion, right? Whether the buyer must approach the consumer court or shall we approach the RERA authority. So I would like to clarify one thing here. One very important thing that you must keep in mind as a buyer, and the complainant is that your case must not run simultaneously in both the courts. You can either approach the consumer court or the RERA court. So the basic difference is the consumer courts work upon the pecuniary jurisdictions. Okay, according to the monetary value that you're claiming, you will go to this district forum or the state forum or the national forum. But in case of RERA, you just need to determine the jurisdiction of your area where the project group is situated, and accordingly you must approach the correct RERA authority, right?
Right. Okay, do we have any questions as of now?
Yes, so we have one query. Okay, so hello NRI Legal Services. Please tell me what is the better option, going to RERA court or going to consumer court?
Who's this?
Hi
Bhupinder, thank you for your question. I'll take this question, Shweta. As Shweta has rightly explained, you can approach any of the courts, but if you are approaching the consumer forum, there is a pecuniary jurisdiction. This you have to keep in mind. Every tribunal has a pecuniary limit and you have to approach the court accordingly. But if you are approaching the RERA authority, there is no pecuniary jurisdiction. If you take my advice, you should approach the RERA authority. Reason being, there are good chances of speedy disposal of the case in RERA tribunals. But make sure you do not approach both the courts simultaneously. Your case cannot run in both the courts, right? So I think this answers your query. Do we have?
Okay, we have another query. So from Parul Ankit Manchanda. Okay, hi NRI legal team. I want to ask that if the allottee changes his mind and stops giving the installments, can the allotment agreement be called automatically cancelled?
No. Hi Parul. Okay, let me understand the question. Okay. No, this is not the right way to, end your relation with the buyer. You cannot do that. You should convey your intention with the builder in writing, preferably, that you are no more interested in buying that property and you want to end the contract between you and the builder. Because the builder is also going to suffer some losses because of the flat cancellation, right? So this is not the correct way. You just simply go and inform the builder you are not going to buy this property because of any XYZ reason. If you are not able to pay the installments or any other reason, you can simply do that and do it in writing. And let me tell you, the builder will forfeit the 10% of the token amount you have given to the builder, because under RERA rules it has to be forfeited by the builder. So rest of the money can be refunded to you, right? I think that answers your question. Yeah.
Okay, so it's from Shruti Jaiswal. Okay, I have been saving money and recently my home loan has been approved, and I have been searching for good home projects, and nowadays markets are rushed with the number of housing projects. That's true. So I am afraid to invest my money in any random builder group as it may turn out to be a fraud. Could you please suggest any way through which I can check the genuineness of the chosen builder group? Thanks for the question, Shruti. So I would like to inform my viewers here that according to the RERA Act, if a builder group is want to get registered and if he's genuine, then he'll definitely get a RERA number and a personal project page over the official website of the RERA authority. So if you as a buyer wish to check the genuineness of the builder group, what you need to do is simply Google the RERA authority's website of your jurisdiction, and over the search bar you need to type the name of the builder group that you want to get informed about, and if it would be genuine, the project page would pop up and then you can go through the information. Okay. Okay, shall we move on to the next question? Okay, it's from Sanchit Malik. Okay, he's saying that I have purchased a property in the town recently and I have the possession, but there are some furnishing works left to do. My question to you is regarding my rights after taking possession of the property. Does RERA provide any covers to us as a consumer? Also, if any issue arises, where shall I go to receive an effective remedy? Shall I move to the consumer court or shall I go to the RERA court? I am NRI, and does NRIs have any special rights under RERA? Okay, so Mr. Sanchit, thanks for your query. See, as we stated earlier in the video, you can approach any of the courts, the consumer court or the RERA court, and definitely you have certain provisions in the RERA Act that gives you cover as a buyer for taking claims of any of the structural deformity or any of you can say the deficiency in services that the builder group has given to you. So yeah, you can definitely approach it. And going on to the next part of your question, NRIs also come under the same provisions of the RERA Act. There is nothing different for the NRIs, so the provisions would go on to you as an Indian citizens only. Coming on to the next query. Hello, if the project is already registered with RERA, can the registration get cancelled by the authority? If yes, what are the circumstances for the cancellation of registration with RERA? Asked by Geetu Mevan.
Hi Geetu. Yes, the registration can be cancelled by the RERA authority under certain circumstances, like if the developer is found doing unfair trade practices, or if the developer is found doing any malpractices on that property, or if the buyers are not very happy with the work that is being done by the developer. In certain conditions, the RERA authority also can suo moto take the action and cancel the registered projects if they have received any serious complaint against that developer. In such circumstances, yes, the cancellation can be done. Yeah, I think your query is answered. Yeah.
Okay, moving on.
Yeah.
So Ankit Kumar is asking, I want your guidance on my matter. I filed a complaint in the RERA tribunal. The builder had not given me possession of the property and delayed it by 4 years. Now they want to compromise with us. They have requested the judge to keep this matter. Okay, so I don't want the possession now and I want my money back. Please suggest relevant course of action.
Okay, who's this?
It's Mr. Ankit Kumar.
Hi Ankit Kumar, you can say no to the offer made by the opposite party. See, the opposite party, the developer can come up with any offer, just to safeguard their interest. They can say that please take the possession now, or they can say that okay, we are ready to refund your money but in installments. They can also say that we are ready to clear all the payment in one go, but give us some discount or release some, just let go of some amount. So they can come up with any offer, but you have approached the authority and you are seeking some kind of relief from the authority. So the adjudicating authority will ask you first whether you are comfortable with taking the offer or not. And if you just want the refund and you don't want the possession now because the developer has already delayed it for like 4 or 5 years, so yes, you can deny it and the case will proceed forward with your claim relief. Speaking about possession only, let me tell you that whenever a developer is contesting the case, he has to show to the court that why the delay has happened in delivering the project. He has to show some reasonable cause to the court. If the court actually feels that yes, the delay was beyond the control of the developer, the court may become little lenient with the developer. But if there is no reasonable cause, the court will pass appropriate directions against the developers. Right?
Shall we take another query? Okay, so Ms. Sonia asks, dear team, can a RERA complaint be withdrawn from the court? And after negotiation, it was promised by the builder that they will make good the defects. We have no further complaints from the builder.
Name.
Okay, it's Ms. Sonia Johal.
Hi Sonia. Yes, you can withdraw the complaint by giving it in writing. But please make sure that the developer is actually giving you for what you have approached the RERA authority. The relief you were seeking for is actually being taken care of by the builder. So please keep the communication in writing with the builder, and if you're confident that yes, the builder is going to give me resolve my dispute so you can withdraw your complaint. Yeah.
Okay. So another question from Mr. Gaurav Sharma. According to the builder-buyer agreement, the possession of my flat was to be given in the month of May this year. I am only waiting till now. I contacted my builder last month and they said it would take 6 more months for completion of the project. Should I wait to file a complaint against my builder, or is there any time period for that?
Hi Gaurav, thank you for your question. There is no time period for filing a complaint with the RERA authority, but I would suggest that you should do it as soon as possible because the developer is delaying the project and the stipulated time has already been covered. So I think you should go and file the complaint, but again, if you have this much confidence with the builder that he will deliver the project within 6 months or after 6 months, then yes, you can wait also because there is no time limitation. I will advise you to keep the entire communication with the builder in writing because the written communication acts as a very strong proof with the RERA authority. If he's giving you this confidence, if he's admitting that okay, I have delayed the project but I will give you the possession in 6 months or so, please ask him to give you this thing in writing via email or through a letter or something, so that after the completion of 6 months you have the proof that he had delayed it intentionally, right?
Shall we move on to the next question? Okay, Mr. Ashwini Kumar is asking, I have signed a buyer-seller agreement with the builder group in Zirakpur. Through some of my sources, I have got to know that the builder might be planning to sell his unfinished project to some other developer. The project is midway and it is not even near completion. Is it feasible for a real estate developer to abandon the project and turn it over to different contractor? I'll take this one. Okay, so Mr. Ashwini, thank you so much for your question. So according to the RERA Act, I would like to inform all my viewers right now that there's another very important provision. So in case a builder group wishes to sell his unfinished project to another builder, there are two very important factors that he must consider for selling his shares or his project to another builder. The first and foremost is the written consent from the RERA authority. He needs to get a written consent from the authority that he wishes to sell his unfinished project, stating reasons why he wants to do so. Another important factor to take into consideration is the 2/3 majority vote of the current allottees or the consumers who have invested their money with the builder group. After these two factors are fulfilled, the builder group can sell their unfinished project to another builder. But again, if you feel that you have a certain kind of threat that they might sell it off, you would definitely get notified prior to that. So I believe after the commencement of RERA Act, that's not an issue that you must be worried about. Okay, shall we move on to the next question now? Okay, so Mr. Harshnur saying questions there. So can the token money given to the developer be claimed back by the lottee?
Hi Harshnur. No, the 10% of the token money cannot be claimed back by the from the developer. Reason being, the RERA actually takes takes care of the interest of both the parties. So the developer has also suffered the loss because of the cancellation of the apartment or flat, whatever. So the keeping in mind the interest of the developer, he will forfeit the 10% of the total consideration amount paid by you. And if you have paid any other additional amount, that you can claim back from the developer, that you can give it in writing that I am cancelling my booking and you should refund the amount by deducting the 10% of the token amount. He will refund it, I think, within 45 days. Yeah.
Okay, so Ms. Iknoor Sandhu asks, hello, can you explain the step-by-step process of filing the criminal complaint? Okay, Ms. Sandhu, that's pretty simple. The first and foremost thing that you need to take into consideration is the jurisdiction, because you do not want to waste your time. Okay, so it's very important to detect the appropriate jurisdiction of the RERA authority where you must file the criminal complaint. After that, the another step is you need to get all the documentation done, which means you must get the original buyer-seller agreement, all the communication details of yours and your builders, everything. It could include the WhatsApp conversations and the call details and everything.
The email conversations.
Yes, and the email conversations. And apart from that, you must also take into considerations the payment details, like how have you paid the earnest money or token money. And after that, you need to visit the RERA website, wherein they have put a very simple format for the criminal complaint. You just need to print it down and put on the details and file the same in the nearest RERA authority of your jurisdiction. As soon as the authority gets your complaint, they would give a notice to the builder group. And after receiving the notice, the builder is obliged to appear before the court, and the court would pass an order which he is obligated to comply with. So it's pretty simple. You just need to get the documentation done and take a printout of the complaint on the original website of RERA.
If you can't do so, you can take help of some law firm or a counsel. Yeah.
So moving on to the next query from Nia Sharma. Lately, I have been reading through various media sources that builders are being caught and sentenced to imprisonment for leaving projects and fleeing the country after taking money from innocent buyers. I am afraid to invest as I feel I might get cheated like that. What if the builders take away my money after signing agreement and then leaves? Is there any provision in RERA Act to ensure the prevention of such fraudulent acts? Yes, Ms. Sharma, you need not to worry about it. I know that like people, we tend to receive such information of fraudulent acts
Yes, a
from the
lot.
news sources and public domain. But after the commencement of RERA Act, there's one very important provision under the RERA Act that states that any builder group who is registered with RERA, he needs to submit a statement with proof stating that the 70% of the total money that he has received from the allottees is deposited in a separate bank account, the details of which are already submitted to the RERA authority. So basically, out of the 100% of the total amount that he's getting for his project group from the buyers, he need to give the details of the 70% of it, and it has been done so as to prevent the frauds that the builder group commit, like they are investing the money of a project group to another project group. So it has been prevented like that. So you do not need to worry about it that much. It has been covered in the new RERA Act. Okay, moving on to another query. After a good time of 6 months, I have finally decided to move forward with a deal of one of the best builder groups in India. However, I was going through the buyer-seller groups agreement and it has a lot of clauses. I am paranoid to sign any such agreement without proper knowledge of necessary clauses. Should I hire a lawyer for assisting me with the documentation work to escape potential fraud, or is there any other way through which I can make sure that the buyer-seller agreement is on point? Being asked by Mr. Ash White. Okay, Mr. Ash, so thanks for your query, but I would like to clarify here, you do not need any lawyer or attorney for getting the documentation of the buyer-seller agreement, because according to the RERA Act, they have a complete format of an agreement which already covers the consumer rights. Even if you are paranoid with moving on with such a agreement format, you just need to make sure that there are few important clauses, right ma'am, like the indemnity clause, or the right to call up the deal, and the clause for the
Jurisdiction,
the subdues and the non-payments as well. They must be there. Otherwise, you don't need any lawyer for that specifically.
Do we have any other question?
No, I believe this is all for today.
Okay.
These are the queries.
I want to state here a very important judgment. So in this case, the buyer approached the court saying that he was not given the parking space by the builder, and actually the builder is willing to sell that land of parking to some other people to create more profit. So the honorable court had observed this fact that under the RERA authority, the builders are there is an obligation on the builders to provide the parking space to the buyer who's purchasing the property from the builder. So yes, he was found violating the terms and conditions, the rules and regulations of RERA authority, and he was directed to provide the parking space to the buyer, right? So I think we don't have any more questions. So I think that's all for today, and we'll be back with another Ask Me Anything session soon. If you have any other query, you can write us at query@nrilegalservices.com.
And if you found our video very informative, please like, share, comment, and subscribe to our Facebook page and our Instagram handle at NRI Legal Services. We would be back with another session soon. Thanks for watching.
Thank you so much.